4 suspects in the murder case of businessman Henry Katanga, including Martha and Kwanzi Katanga, Patricia Kakwanza daughters, Amanyire George and Otai Charis, have appeared before Nakawa Chief Magistrate's Court. Prosecution prayed to court to commit the accused to High Court for trial. Since inquiries into the case are complete, court first read the summary of evidence and exhibits that included a pistol, alleged to have been used to murder Henry Katanga, laboratory test reports, ballistic expert reports, telephone reports, residues from the pistol, and how the 4 participated in committing the offense.
Katanga Mole, Kwanzi Patricia, Kwanzi Martha Katanga, Otai Charles, and Omanyire George, the accused persons. Summary of the case under section 168 and 169 of the NCA. The Director of Public Prosecution proposes to adduce evidence at the trial to prove the following facts: that 1. The deceased Katanga Henry and the A1 Mole Katanga were living together as husband and wife at Imbuya, Chwatu Road, Nakawa Division, Kampala District. The two had been married since 1991. 2. Both the accused and A1 together raised 4 children, among whom is A2, Patricia Kwanzi, A3, Martha Kwanzi Katanga. A2 and A3 have since been married and lived in their separate homes. Number 3, at the time of the commission of the offense, the deceased and A1 lived with A5, Amanyire George, and as their helper, Shambabon, together with other workers and relatives. Number 4, a few days before this death, the deceased revealed to a close relative that he feared for his safety because he was being tracked by his wife, A1, and feared that he would be killed anytime. Further, that he needed to meet a lawyer to prepare a will just in case he died. Number 5, with the help of the close relative, the deceased procured a safe to secure his important documents. He also secured an appointment with a lawyer to discuss matters of his safety on the 2nd day of November 2023. Number 6, as a result of his fears of being trapped, the deceased made efforts to change his phone password, acquired a new private telephone line, and rarely made frequent movements in his known personal motor vehicle. 7. The evening of 1st November 2023, both A1 and the deceased returned home, had dinner together, and retired to their matrimonial bedroom where they slept. 8. On the morning of 2nd November 2023, the people at home woke up and went about their normal business, except the deceased and A1, who remained in their bedroom. Number 9, while on their morning duties, A5 had strange noises coming from the bedroom of the deceased and A1, and immediately alerted the rest of the people in the house. Number 10, has moved closer to the bedroom, to ascertain what could be happening, they had a struggle inside the bedroom, and they separated. They suspected that the two, A1 and the deceased, could be fighting, and immediately telephoned the A2 and A3 to come and ascertain what was going on between their parents. 11. Before the arrival of A2 and A3, the workers heard loud blasts, and immediately the noises in the bedroom stopped. 12. A1 opened the door to their bedroom and walked to the adjacent room, where she called the A5 and instructed him to call her daughters A2 and A3 to come. 13. On approaching the bedroom where A1 and the deceased slept, A5 noticed a trail of blood from the master bedroom to the room where A1 was seated. 14. Shortly after A2 and A3 arrived at the home, A3 remained downstairs as A2 went up to the bedroom of A1 and the deceased. A2 saw the deceased in a pool of blood and went to the adjacent room where she found A1. 15. A2 and A5 assisted A1 downstairs to the motor vehicle, and A2 drove A1 to Golori Medical Center, leaving A3 behind together with the rest of the workers. Number 16, A3 eventually moved upstairs to the master bedroom, where she observed the deceased lying hopeless in a pool of blood on his bed. She, A3, picked the mobile phone of the deceased and locked the bedroom. She, A3 in brackets, then gave instructions to A5 to clean the blood that was outside the master bedroom, leading to the adjacent room. 17. A5 inquired from A3 about the condition of the deceased since he, in bracket the deceased, hadn't been seen out. A3 respondent that he, in bracket deceased, was okay, only that he was still sleeping. Number 18. A5, not believing A3's response, called on the telephone number of the deceased to find out whether he was okay, but instead A3 confronted him with the deceased's phone in her hand and questioned A5's actions of calling the deceased's phone as opposed to cleaning the blood and as instructed. 19. During that time, whether attempted to reach the deceased through his phone, he was informed by A3 that the deceased was well but only still sleeping. 20. After a short while, A2 returned at the home with A4, A2 and A3. A3 and A4 went upstairs to the master bedroom and closed themselves in the room for some time. 21st. Thereafter, they opened the door and called A5 upstairs. On arrival, he instructed to bring a small mattress, which he did. Number 22. A5 was now allowed inside the master bedroom, where he saw the deceased lying on the bed, lifeless, and inquired from A4 as to whether his boss was still alive. F4 responded to him that he was dead. Number 23, F4 then asked F4 to assist him. F4 then asked F5 to assist him lift the deceased from the master bedroom onto the small mattress on the floor in the bedroom. There was blood all over. Number 24, A2 and A3 instructed A5 to clean the blood inside the master bedroom while he started doing as F4 called the area police reporting an incident of alleged suicide. Number 25, shortly after, the police arrived at the scene and found F5 cleaning the blood in the master bedroom and instructed him to stop forthwith. Ginger Road Police Station was notified and a team of officers went to the scene. Number 26, by the time police arrived at the scene, they found an A+ funeral van. On inquiry, the police were informed that the body was en route to Bombo Military Hospital. The police stopped them from taking the body anywhere and took over the scene and commenced inquiries into the circumstances leading to the death of the deceased. Number 28, the body was taken for post-mortem examination at Kampala City Mortuary, Molago. Upon examination, the body was identified as that of Katanga Henry, a male adult. It had a stainless sharp gunshot entry wound on the left temporal scalp area. It also had a still sharp gunshot through the right external auditory meters. The cause of death was gunshot injuries. The PF4 8B shall be relied on during the trial. Number 30, at the scene of crime, police recovered one pistol, one live ammunition, one cartridge casing, one projectile, one pistol box containing 17 rounds of ammunition, among others which were exhibited. The PF-19 shall be relied on during the trial. The police retrieved the information relating to the ownership of the pistol recovered at the scene, and it was established to have belonged to the deceased. The SOCO visited the scene and picked several samples for forensic analysis. On the DNA examination of the pistol, it was found that A1's DNA was the most predominant on the trigger. The DNA analyst's report shall be relied on during the trial. 33, the pistol was also submitted to the ballistic examination, and it was established that it was in good working condition, capable of discharging live rounds of ammunitions. The cartridge cases found at the scene were discharged by the pistol to the issue. the ballistic expert report shall be relied upon at the trial. Number 34, the residents of the deceased and A1 had a CCTV installation in and around the premises. On police examination of the CCTV system, it was discovered that critical cameras had been tampered with. The CCTV report shall be relied upon during the trial. A sketch plan of the scene of crime was developed by the scene of crime officer and shall be relied on during the trial. 36. Police recorded statements of all the people found at the scene. F4 and F5 were arrested for further interrogation. 37. F4 and F5 were examined and the PF224 both were found to be adults with normal mental status. PF24 shall be relied on during the trial. The police established that A1 was first taken to the Bolobi Medical Center by F2 and later to International Hospital Kampala, IHD by A2 and F4. Police immediately visited A1 at IHD and picked swabs from her hand, which on examination were found to be positive for powder residues. Number 40, the police medical examination team examined the A1 PF3A on 9th November 2023, and A1 was found to be fully conscious and responding to command. Well oriented on time and place, the examination also found that she had several injuries which were classified as previous harm. Number 41, A1 recorded a statement in which she disclosed that on the night prior to the incident, she spent a night together with the deceased in their bedroom, but denied knowledge of what transpired and how she got to the hospital. 42, telephone communications of the deceased and all persons were analyzed. The telephone prints and the reports shall be relied on at the trial. All the accused persons were accordingly charged to court. Prosecution shall, among others, tender and rely on the following documents exhibited. Postmortem report. Yes. 1. Postmortem report. Deceased. PF24 in respect of the accused persons. PF19 exhibit slip. Items indicated on the exhibit slip. Sketch plan of the scene of crime. Forensic report. Telephone printouts. PF17 is PF3 in respect of A1, SOCO report and photographs. Whereupon prosecution shall contend to the accused persons have no valid defense for their actions and shall pray that they be convicted and as indicated.
Your Worship, this is one of our clients.
Magistrate Elias Kakoza committed therefore to High Court for trial.
bakunganyiziddwa era oludda olwabwe lujja kwesigama ku bujulizi obwo nga babawozesa mu high court era ne kooti eno nebasindika mu kooti enkulu obujulizi butandika okuwozesebwa.
Prosecution also prayed to court to issue a warrant of arrest against Katanga, wife to the deceased, although the prayer was objected by the defense legal team.
Your Honor, I didn't know that prosecution was a very difficult job until but I know my colleagues know that we are here to simply do our job in accordance with the law. Your Honor, court appearance is obviously a painful process. But those subject to the law must undergo it, because that is the only road to take if justice is to be administered. So, Your Honor, appearance cannot be at the will or convenience of a party. Yes, we agree that in the indictment we mention a grievous harm, but Your Honor, that examination we refer to is as of the 9th of November last year. 9th November 2023. It can't be relied on as an authentic status now. Then, Your Honor, the report, this letter addressed to the next of kin dated and stamped today, just to be sure if court has a copy of this. Yes. Your Honor, this letter is not addressed to this court. Number two, it talks about 6 weeks as from the 12th of December, and a simple mathematics shows that actually 6 weeks, the said 6 weeks, have lapsed. But most importantly, this letter, even if it had been addressed to court, it does not speak to her inability to answer the court process. There's nowhere that the doctor is saying that A1 should not answer the court process. It is not there. But again, Your Honor, we want to be very careful, and we invite this court to be, because like we submitted, that the system of waiving expert evidence from the bar by members of the bar who are not medical experts runs a risk of, one, misleading court on issues where our expertise does not lie, but two, it borders submission of evidence from the bar which is not only an unacceptable practice, but which would also render such submitted evidence inadmissible. We, as members of the bar, cannot authentically explain expert reports. Then unfortunately, this is not also evident evidence that could be tendered and admitted for reliance. As I invite my land senior colleague to sum up our rejoinder, Your Honor, I want to emphasize that the criminal justice system has a clear mechanism of handling sick inmates. This court is not short of the power to make appropriate orders if an inmate or suspect in this matter is produced before it. The prison system also has a clear mechanism. The prison system specifically. Yes. Yes. This is exactly, Your Honor, that I'm addressing. That the prison system has a clear mechanism.
Your Worship, we didn't get the question that you had asked.
The question was, you said, what is not short of? Now, I was saying, yes, we should one of us and their choose.
The prison system has a clear mechanism of handling sick inmates. In fact, as this court may be aware, there is a whole hospital. Now, this is a matter of judicial notice, that there is a hospital in Maction Bay, which is part of the prison facility.
I'm not objecting. I didn't let came from our submissions.
I am trying to address.
I asked myself.
Yes, and I also don't know if my landlord is asking for the court to discharge the patient and admit her in another hospital.
Relax. You see, the court has asked me to demonstrate how the system deals with the scenario. You know, you're on the Maction Bay Hospital is a retention facility for inmates that are unaware. And Your Honor, it's also a question of judicial notice that if the prison doctors, who are equal professionals in the medical field, assess that they cannot handle a specific situation of inmate X, they even make referrals to Mulabo National Referral Hospital. I want to submit, Your Honor, that this system exists to address situations such as this, where sickness may be used to curtail appearance of persons who are subject to court process. I invite my land sister.
As I talk now, we have very many inmates in New Zealand who are sick. Court. We even have now mothers giving birth in New Zealand, but answering to court. These are not any special, Your Worship. Your Honor, in a criminal trial, there are very many stakeholders. We have court, we have the DPP's office, we have the public, we have the relatives of the deceased who are also looking for justice, but we also have 4 other accused persons who have now since been committed to the High Court.
Your Worship, I am afraid my senior colleague is bringing new matters. This is a rejoinder. The issue of stakeholders, the issue of complainants was never raised. I don't know where she's bringing that from, unless we're going to be allowed to respond to it, Your Worship.
Your Honor, it is common knowledge that all these are parties to a criminal trial. And all these people, Your Worship, we all can't receive justice because of only one person who has, on several occasions, absconded from appearing in this court, even when court has been gracious in giving criminal summons. We therefore reiterate our earlier prayer that this court be pleased to issue a warrant of arrest against A1. We so pray.
The Employment Act provides for a time of maternity leave. My colleague got a warrant when somebody was supposed to be on maternity leave.
That was concluded.
Now,
A warrant was applied before the respect of accused number 6.
yes, now,
And we issued it. So now,
I'm coming to this one because this is a precursor to this one. My Lord, we came from somewhere to arrive here, and that road is uncomfortable. I can understand why the court doesn't want to go there. But I'm warning the court not to go the same road by issuing this one for a patient. That's where I'm coming from. My Lord, this is the first court. There are 2 other 3 courts after here. And that's why I want this to be on record, because of the way we are conducting this matter. So my Lord, what I am saying is that the road we traveled then, we shouldn't travel it now. And please record me, my Lord. The state applied for a warrant of arrest for a fresh mother who has since been separated from her child. And they got granted. We are back to that unfortunate day where the state is again applying for a warrant of arrest for a hospitalized 53-year-old woman who the state has described to have grievous harm in their indictment in paragraph 40. My Lord, I invite this honorable court not to travel that same slippery road. We have traveled that road before. We have a young mother in jail. We shouldn't have a patient in jail. The court shouldn't able the DPP. I don't know what the DPP has agreed to do. Whether the last bit of prosecution has become into persecution, but this court, I invite the court not to travel that road with the DPP, to reject the prayer for a warrant and extend summons until the accused A1 is healed and discharged. And only then, why are you in a hurry to try A1? What if she dies in hospital? Wait for her to be discharged and then try her. And there are enough cases to try, my Lord. That's why I was giving you a history so that we don't travel that road again. We require a chair for that fresh mother. Should we require many chairs for the new one? Let's not travel that road again, my Lord. That is our prayer. Allow A1 to heal, and then we can charge her. Let's not specialize in arresting young mothers and patients from their hospital beds. If the police wants to do so and the prosecution, let them do so without the aid of this court. This court has aided them before to arrest a fresh mother. You should not aid them again. We are much obliged.
Just to go through the history of the matter, on the very first appearance, it was the DPP themselves who informed court that the patient was hospitalized. On the 8th of January, it was Mr. Jonathan Modena himself who, after asking for a warrant of arrest, then said that information like the medical reports don't reach him on time, that the DPP is not fond of communicating because it's a very big office. The information doesn't reach him, but he said he concedes that A1 is in hospital. Your Worship, I am rather at loss that someone is asking for an arrest warrant to be executed on a hospital bed. They may not like A1 much. They may have their enemies towards her, but an arrest warrant on a hospital bed is really, frankly, improper, and is asking this court to do something incredibly improper. Nonetheless, Your Worship, the evidence from the hospital, my land, we have not been, the other point, we have not been making these claims merely from the bar. The evidence from the hospital has been in writing, either to the state or to the police. So every time this court has extended criminal summons, this court has done so properly. We have been told of a review coming up to see after the operation. The hospital has gave us 6 weeks. They have always known of these 6 weeks. My prayer, another prayer, for this court to be pleased to extend the summons, but we shall, and we also pray, Your Worship, that you give us your benevolence that as soon as our client is discharged, notwithstanding whatever the date of the summons may be, we present her in court on the day of discharge. We pray that you extend the summons, but no matter the date of the summons, if our client is discharged before the date of the summons, we shall present her in court as soon as she is discharged.
Magistrate Elias Kakoza, however, issued a warrant of arrest.
On the 4th of December 2023, the state applied for warrant of arrest, and Mr. Karuhanga told the court that accused number 1 was still admitted and had serious injuries. He showed the court some pictures, and the court extended criminal summons for both accused number 1 and accused number 3 till 18th of December 2023. And on 18th of December 2023, counsel for the accused attempted to apply for bail in respect of the accused who are present. That is accused number 2, 4, and 5. And I declined to entertain a bail application, and they said that the court, with the jurisdiction to handle the grievous offense, would handle bail application. Accused were further remanded, and the criminal summons was extended in respect of accused number 1 and accused number 3. This matter came up on 8th of January 2024. Warrant of arrest was applied for in respect of A1 and A3, again by the state. Court issued warrant of arrest for accused number 3 after hearing that she was attending hospital from home but could not attend court. For accused number 1, criminal summons was extended to 22nd of January 2024, which is today. 2 days after 8th, that was on 8th of October, 8th of January 2024, accused number 3 was brought to court by her lawyers. Now, as regards accused number 1, she has been on criminal summons since 21st of November 2023. Today, the accused counsel are applying for extension of criminal summons, saying that accused number 1 is still unwell. They have shown court a letter addressed to the next of kin on the medical condition of accused number 1. Though this letter is not addressed to court, and even affidavit sworn by medical personnel accompanying the medical report, or a letter, or someone showing that these people an affidavit sworn to that effect, and they were brought to court. On the letter dated 22nd January 2023, I believe it is a mistake. It's 2024. In the letter is indicated 2023. I believe it was written today, 2024. Yeah, you can look at it. Yeah. In paragraph 3, it was said that on 12th of December 2023, a successful A1 successfully underwent her 5th surgery and would remain in hospital for 6 weeks. As observed by State Jonathan, I've counted the 6 weeks and they're ending tomorrow. As court, we really don't understand the condition of the accused. And I agree with the state that there is a mechanism in handling sick people. There's hospital and prison. Also, the accused, if the accused brought in warrant of arrest, can apply for bail to the competent court on the basis of her condition. This court will therefore go ahead and issue warrant of arrest in respect of accused number 1. Briefly, these are the point, of course, that one, the accused, we don't know the condition of the accused as court, apart from reports to the DPP, letters. 2, we don't have an affidavit sworn by a medical officer, personnel, everything that should the accused. 3, if accused brought on warrant of arrest, can apply based on her condition to court of competent jurisdiction, or if taken to prison, can attend hospital from prison. And since now this matter is committed to High Court, we give it a date.
Mole Katanga, wife to the deceased, is reportedly hospitalized at IHK for injuries she allegedly sustained during the shooting of her husband, Henry Katanga. Court has set 12th February 2023 for Mole Katanga to appear in court.